Hello everyone. A very good evening, a very good afternoon to all of you. Welcome to the Law Entrance channel of Adda 24. Welcome to the Officer Adda channel of Adda 24/7. So right now we are doing the summary of the act and the important sessions of your BRBL book. Okay. So we have already completed module D and right now module C is going on. So that's why this session is very much important. Okay, so I hope so. My voice is audible to all of you and the screen is visible to all of you. Right, guys? Okay, so let's do the summary and the Macmillan most important question of this session. Okay, today's session we are going to start the Integrated Ombudsman Scheme and one more act, that is a Consumer Protection Act 2019. So what is special about this act? So we have to understand this topic. So first of all, Integrated Ombudsman Scheme. Before starting this particular session, we know that we have a code in which we can just go for the justice. But instead of code in India, right now we have a ADR system, that is an alternative dispute resolution. So in the alternative dispute resolution systems, we have a what? Ombudsman, we have a ombudsman, we have a basically consumer forum, right? Consumer forum. Then we have a arbitration, conciliation, mediation. So there are so many, we can say that there are so many, this one, the ADR system in India, where we can just put our dispute and the justice will be given to us. Done? So right now we have a one integrated ombudsman scheme. So this integrated ombudsman scheme, that is the merger of three schemes: banking ombudsman scheme, NBFC ombudsman scheme, and then the digital transaction ombudsman scheme. So right now we have just merged three schemes into the one act, that is the Reserve Bank Integrated Ombudsman Scheme 2021. Just like in India, we just want one nation, one law. Same thing in the case of ombudsman, we need one dispute, one ombudsman. Is that okay? So this is basically established by the Reserve Bank of India. Okay. So this scheme has a very wide coverage, include most bank, financial institution, and the system participant dispute. Is that okay? Beside providing the definition of the term most often used in the scheme at the various places, the scheme deal with the location of offices of ombudsman appointed under the scheme and their power and the customer grievances, etc. So these are the things, this is, in the act. Now, we have a CRPC. What is CRPC? Centralized Receipt and Processing Unit. So what exactly this means? The scheme speak about the setting of CRPC where we can send our complaint for the processing of the customer complaints, okay, relevant to the scheme, and then the staffing of the Office of Ombudsman and the CRPC. The scheme also has provision for the party to the dispute appealing against the decision given by ombudsman. Suppose guys, first of all, you have to just file a complaint to the regulated entity. If they have given the reply, it is okay. If the dispute is solved, it is okay. Otherwise, you can go to the ombudsman. And still, if you are not satisfied with the decision of ombudsman, you can go to the appellate tribunal. So this is the basically, criteria of filing the appeal. The scheme allow RBI through an order to suspend such period as may be specified in the order and the operation of all or any of the clause of scheme either generally or in relation to the any specified regulated entity. So in this scheme, the regulated entity includes bank, NBFC and the system participant. So this is called what? Regulated entity. Tell me class, is that okay? Yes, class. Is that okay? Please tell me. Any doubt? Hanji class, any doubt? Please tell me. Any doubt? Done. Now let's do the question. Under the scheme, who is appellant authority? Governor, finance minister, deputy governor, and it's the elective director of RBI. What is the right answer? Tell me. Number one question on the screen is that. Tell me the right answer. Hanji class, tell me the right answer for this question. Who is the appellate authority? When we were studying in JIB, the integrated ombudsman scheme, so this was deputy governor. But right now, who is the appellate authority? Appellant means from ombudsman to appellant. So what is the name? Who is the person who will act as the appellate authority? Tell me. The right answer will be executive director of RBI. What is the maximum period for which an ombudsman, deputy ombudsman may be appointed under the scheme? What is the maximum tenure? 1 year, 3 year, 4 year, 10 year. What is the right answer? Tell me, guys. What is the right answer for this question? Tell me, tell me. Yes, class. What is the right answer for this question? The right answer will be 3 year. That is the right answer. Okay? Next. All complaint may be sent under the scheme to the CRPC only. That whatever the complaint, if the customer is complaining, it should be sent only to the CRPC, then our matter can be solved. And the CRPC is situated or established in Chandigarh. Always remember, there is a one only place, okay, that is Chandigarh, where the CRPC is there. Excellent, Nidhi ma'am. The right answer will be 3 years, the right answer. Good, ma'am. So all complaint may be sent to the CRPC. That is not necessary. So this is false. This statement is false. Okay, now, if complaint made by customer to the regulated entity is not replied, what is the minimum period? Minimum after its receipt by a regulated entity, may the customer make complaint to the ombudsman. It is 1 month, 1 year, 6 months, or 3 months. Excellent, Nidhi Jha ma'am. That's great. What is the right answer? What is the right answer? Excellent. Anirudh Ghosh sir, how are you? A is the right answer. An ombudsman would send copy to the complaint received by customer to the regulated entity. The ombudsman would send a copy of complaint, okay, received from a customer of a regulated entity. That is right. That is true and false. Is it necessary? Is it necessary or not? Tell me. The answer will be what is the right answer? That is absolutely true. That is absolutely true. So fifth one, A is the right answer. Is that okay? So class, this is all for integrated ombudsman scheme. That is a very small act, and now we will do the another act. Now guys, we will do the another act that is important for the examination point of view. So C class, in the paid batch, I always used to give you the summary and the definition, but I know that you people don't do. So that's why the summary of the act, that is of your Macmillan book, is in front of you. And whatever the question that is given in the BRBL book, that is also in front of you. So please do all these things. Next, the Consumer Protection Act. So guys, in the Consumer Protection Act, basically, this act is of 1986. Right now, we have to study the 2019 one. That is the latest one. Okay. So the Consumer Protection Act was enacted on 9th of August 2019. Come into force 20th of July 2020. That is not so much important. So what is a new thing that is added in this 2019 one? The first is Central Consumer Protection Authority. Central Consumer Protection Authority, which come into effect from July 24, 2020. So that is authority which is basically made under this one. Section 2 define the major terms which are found occurring in the act. And also we have a council. We have a Central Consumer Protection Council. We have a State Consumer Protection Council. We have a District Consumer Protection Council. These are the advisory council, mainly to render advice on the promotion and what protection of the consumer rights under this act. That is important. That is important. Okay. So basically we have to study about the authority. We have already read. We have a study about the council, and then after that we have to study about the commission. So commission, you can see the type. District commission we have to study, state commission and national commission that we have to study. Is that okay? Done? So that's all for the summary session. Let's do the question that is given in the BRBL book. Now, okay, one thing is there. Yeah, commission. If we talk about the jurisdiction, okay. So I'm just making this one. In 1986, in 2019, in 2021, right? Then this is district commission. This is state commission. Next is state commission and then national commission. Done? 3 commission. So first of all, in district commission in 1986, up to 20 lakh was the matter. State commission 20 lakh up to 1 crore. And national above 1 crore. 2019, this is up to 1 crore. This is 1 CR to 10 CR. And this is above 10 CR. 2021, if we see this, up to 50 lakh. This is 50 lakh to 2 crore. And this is above 2 crore. So guys, we have to learn. We have to learn basically 2019 one, this one, okay, and 2021, because you have to study 2019 Act, you have to study 2019 Act, but the 2021 amendment is also there. So that's why you have to study both these 2-year jurisdiction. That is very, very much important. Okay. One thing I would like to add in this one, see, suppose Nikita ma'am is there. This is district commission, this is state commission, this is national commission, and this is Supreme Court. This is Supreme Court, right? So if Nikita ma'am is not satisfied, or Nikita, the dispute is there, and she have to file the case in the district commission. So Nikita ma'am have a 2-year in which she can file case to the district commission. Same, Nikita ma'am have a 2-year if she want to file directly case into the state commission. And Nikita ma'am can file the case in the national commission, that is in 2 years. So 2 is the limitation. Is that okay? From district commission to state commission, we have a 45 days in which we can file the case. From state commission to national, we have a 30 days. From national to Supreme Court, we have a 30 days. And always keep remember, if you want to file appeal, so you have to pay 50% amount, you have to pay 50% amount if you want to appeal. And for Supreme Court, no amount you have to pay. For Supreme Court, guys, no amount you have to pay. So this is very, very much important. This one. Okay, 50, 50, 45, 30, 30. This is 2 year. Okay, guys. So I hope so you people understand this topic. That is very, very much important topic. Is that okay? Now let's do the question. Number 1 question. Which of the following is not complainant under the provision of Consumer Protection Act? Any voluntary consumer association registered under any law, the mediator, the central authority and the legal heir, or the legal representative of a consumer? What is the right answer? Tell me. What is the right answer for this question? Tell me, guys. Yes, class. What is the right answer? Which of the following is not a complaint under the provision of Consumer Protection Act? So for this one, the right answer will be mediator, because mediator is another form of ADR which is there in 2019 Act. So B is the right answer. Good, Anirudh sir. Okay, next. Consumer includes a person who buy a goods and services for the commercial purpose. That is the definition of goods, class. Sorry, that is the definition of consumer. Consumer includes a person who buy a good and services for the commercial purpose. Tell me, class. That is totally false. That is totally false. Okay. A consumer includes a person who buy goods and services for the commercial. This is totally false one. Okay, because consumer is not a person that is buy the goods and services for the commercial and for the resale. Done. Next. Which of the following is the chairperson of Central Consumer Protection Council? It means from where we just select the chairperson. So you can see, Nidhi ma'am, Anirudh sir, these are the summary and the questions that is given in the book. So please do revision. The right answer is chairperson. We know that we have a Central Consumer Protection Council, State Consumer Protection Council, District Consumer Protection Council. So we just select the chairperson from the minister in charge of the department of this. This is for national and for the state also, and for the district, collector will be there. For the district, collector will be there. I hope so you remember the collector in the district. Hello everyone. A very good evening to all of you. A very good afternoon to all of you. Welcome to the Officer Adda 24/7, the spatial session of your BRBL subject in the English medium language. So you know that this session is very, very much important for the examination point of view, because in this session we are just doing the summary of the act, okay, and the question and answer of your BRBL book. So if you are new in this session, first of all, do not forget to enroll in this session. Okay, enroll or like the session and share the session as much as possible. So guys, we are doing the, you know,
the questions of module C, then after module B, and then after module A, we will do the questions of the Macmillan that is given in the BRBL book. So today's session is, as you can easily see, that is your MSME Act. Okay, MSME Act. So what exactly this act means? First of all, the full form of MSME is, that is Micro, Small, Medium Enterprise Development Act 2006, which become operational from 2nd of October 2006. We know that if we are a rich person and if we have a good family background, we can easily do our business. But suppose if the person belong to the ruler family, so for them it will be very difficult for them to just open the business. So this act, that is MSME 2006, is basically started from 2nd of October 2006. The statute has a different definition for the micro, small, medium manufacturing and the service enterprises based on the both investment and turnover. Okay, the act provide for the establishment of the National Board for Micro, Small, Medium Enterprise, then Advisory Committee for MSME, which have a specific function as brought out in the act, and the Micro Small Enterprise have a Facilitation Council also. What is Facilitation Council? The Facilitation Council is basically just for the solve the dispute that's come under MSME Act, okay, which mean to see settle the dispute among the parties in respect of the MSME enterprise. So that's why this is very important for the examination point of view. So in the MSME Act also, we have to learn first of all what is the investment and turnover of the micro enterprise, small enterprise and medium enterprise. And then after we have to study about the National Board, Advisory Committee and the Facilitation Council. Done? Now see. Next thing that is written here, the buyer from a MSME. Okay, so what is written here? The buyer from MSME has to adhere to agreed payment date, which should not be more than 45 days from the acceptance and deemed date of acceptance as per the law, failing which such buyer has to pay compound interest with a monthly rest on that amount and from the appointed day, or the case may be from the date immediately following the date agreed upon at the 3 times of the bank notified by the Reserve Bank of India. So this day you have to learn. A dispute between the parties where a MSME is involved, where the payment is not made in time by the buyer, it may be referred to the Facilitation Council. And for in the Facilitation Council, there is a conciliation and then after the arbitration. Any buyer who is required to get his annual account audited under any law for the time being in force is required to furnish additional information in his annual financial statement as regard the amount of principal and interest not paid by the buyer to MSME on the balance sheet date. There is also provision for penalty being imposed at the rate detailed in this one. So we have to learn these much of things in the act. Okay, so this act is basically what is the tenure, what is the particular investment you have to learn, about the board, about the advisory committee, and about the facilitation council. So these are the important things in MSME that you have to learn. Is that okay? So I think that is clear to all of you. Now let's do the question of MSME. So whatever the summary that I'm teaching you in the session, each and every summary I'm just giving you in the paid class also. So this is a revision, and if you revise by yourself, that is a quick revision that is done by you. Okay? Now the first question. Which of the following statute provide the current definition of MSME in India? MSME Act 2006, the Delayed Payment Act 1993, the Minimum Wages Act 1984, or the Factory Act 1948. What is the right answer? Tell me, class, what is the right answer? Yes, class. What is the right answer? Which of the following state you provide for the current definition of MSME? The right answer is MSME Development Act 2006. So for the first one, A is the right answer. Okay. MSME are governed by which of the following ministry? Ministry of Financial Service, Ministry of Commerce and Industry, Ministry of Small Scale Industry, and the Ministry of Micro, Small, Medium Enterprise. What is the right answer? MSME is governed by which of the following ministry? Tell me. Is that Ministry of Financial Services, Commerce and Industry, Small Scale Industry, or Micro, Small, Medium Enterprise? Which of the following is the right answer? We know that whenever our government is there, so in each government there is a ministry. So for MSME also the ministry is there. So the MSME governed by which of the following ministry? That is Ministry of Micro, Small, Medium Enterprise. So for the second one, D is the right answer. Is that okay? For the second one, D is the right answer. Next. Where application is made to a court by the buyer for setting aside the decree which is made by facilitation council. So we know that in MSME the conciliation and arbitration is the facilitation council. They have to give justice within 90 days, and if conciliation is not able to give justice, then the matter will refer to the arbitration. For arbitration also 90 days will be given. Suppose if we are not satisfied with the decision of conciliation and arbitration, so we have to file the case. We can file the case in the court. That is written here. So, where application is made to the court by the buyer for setting aside any decree award made either by facilitation council or by any institution center providing alternate dispute, then how much percentage? Now, what is the question? The question is, what percentage of amount of decree and award is to be deposited with the court by the buyer? So in this one, the right answer will be 75%. Otherwise, in each act, we have learned that we have to pay, if we want to appeal, we have to pay only the 50%. But this is the only act where the percentage amount is 75%. So this is the right answer. Okay, so for this one, you have to learn the investment and the turnover also. Is that okay? So this is all about your MSME Act. Now let's do the second act, that is Insolvency and Bankruptcy Code. Okay, now the first one about the Insolvency and Bankruptcy Code. C class. We know that in India, for the bank dispute, we have a Lok Adalat, right? We have a Lok Adalat. Then we have a Ombudsman. We have a Consumer Forum. We have a Tribunal. And in your syllabus, we have a DRT, that is a Debt Recovery Tribunal. Okay, so in insolvency and bankruptcy matter also, the matter will be solved by the DRT. The matter will be solved by the Debt Recovery Tribunal. So, recognizing that reform in the bankruptcy and insolvency regime are critical for improving the business environment and evaluating the distressed credit market, this board was passed by the government that come into force in December 2016. Okay, the structure have a 4 pillar. So what are the 4 pillar? The first one is, you can see here, insolvency professional. Second is information utilities. Third is adjudicating authority. The fourth is IIBI board. So first of all, you have to learn the 4 pillar. Just like our government have a 3 pillar, that is legislature, executive and judiciary. So same in IBC also, we have a 4 pillar: insolvency professional, information utilities, adjudicating authority, and insolvency and bankruptcy board of India. So you have to learn this one. Next, if a default is above up to 1 crore, because this 1 crore has been amended, before it was only 1 lakh. So in 2020 it is amended. The creditor may initiate the insolvency process in the 2 stages. So what are the two stages? The first one is insolvency resolution process. The second one is liquidation. Is that okay? Now see, when the corporate insolvency resolution process against a corporate debtor is initiated by the financial creditor, for example, the bank, it may file application to the adjudicating authority when default has occurred, along with the record name of the interim resolution professionals. What is interim? That is a temporary resolution professional. Is that okay? So this is the process by which we solve the matter. The application, if admitted by the adjudicating authority on being satisfied with it, result in the commencement of the resolution process. Under the code, the entire resolution have to be completed within 180 days, but it may be extended for the valid reason for the maximum 330 days. This is very important. So basically within 180 days they have to give justice, and it can be extended up to the 330 days, in which the interim resolution professional initially and the resolution professional letter on the play a vital role along with the committee of creditor. Under liquidation, the sale proceeds would be distributed as per the order of priority detailed in the code using the waterfall mechanism. Now class, in this act we also have a fast track insolvency resolution process and the pre-packaged insolvency resolution process, that is for the MSME. The corporate person also enter into the voluntary liquidation proceeding as per the provision of the statute. So that is important. Okay, now let's do the question. Let's do the question of MSME, that is important one. The first question on the screen is that in respect of the right real estate, what I'm saying, in respect of the real estate, okay, of a corporate debtor, what is the minimum number of allottees who have jointly filed for initiation of corporate insolvency resolution process? Tell me class. That is important one. This thing you have to learn. This thing you have to learn it. That is important one. So tell me class, what is the right answer for this question? What is the right answer for this question? Hanji class, tell me what is the right answer? In respect of the real estate project of a corporate debtor, what is the minimum number of allottee who have to jointly file for initiation of the corporate insolvency resolution? You have to learn for this question 100 allottees or 10% of the total number of allottee, whichever is less. So for the first one, B will be the right answer here. You have to learn this. Next, in how much time is given by adjudicating authority to rectify the defect? Because see, if adjudicating authority will admit, it is okay. If they reject, so they have to give the time to the opposite party to rectify the defect. So within how many days they have to give it to the this one, rectify a defect in the application of a financial creditor for initiation of corporate insolvency process against the corporate debtor who has defaulted? Tell me, within 7 days, 5 days, 15 days, or 10 days? What is the right answer? In how many days they have to rectify it? Tell me class, what is the right answer? Yes, class. For this one, the right answer is within 7 days they have to rectify the defect. So this is the right answer. Second one, A is the right answer for this question. Okay. Now, the last question that is given in your book. Under the IBC 1 2016, which one of the following person is entitled to make application to initiate the corporate insolvency process? It means who will initiate the process. The first is given the corporate debtor already undergoing this process. Second, corporate debtor in respect to whom liquidation order has been made. And the pre-package insolvency process is going on. So if all the three things is going on, so I don't think that they have allowed to initiate the corporate insolvency process. So Geeta ma'am, the right answer will be, that is D. D will be the ma'am right answer, Geeta ma'am. Okay. Why? Because you can see that because the matter is already going on, liquidation process is going on, and the pre-package insolvency process is going on. So that's why none of the above will be the right answer. So third one, D is the right answer. Is that okay? So class, okay, what is a motive of enactment of insolvency and bankruptcy code? What is a motive? To consolidate and amend the law relating to reorganization, insolvency resolution process, partnership firm, and this to maximize the value of asset of interested person to increase the ability of credit. What is the right answer? Tell me, because these question I think that is not written in the book, that is just for the basic. The right answer is A is the right answer. Applicability of this code shall be applicable to company, LLP, personal guarantor, and all of the above. That is important one. So the right answer is all of the above. Is that okay? Who are considered the corporate person under the provision of the code? Company and LLP, company unlimited, no. Financial service provider, no. The right answer is company and LLP. So A is the right answer. Who are the person who initiate this CAIRP? Only corporate debtor, financial creditor, operational creditor, financial creditor, operational creditor, corporate debtor, that is given in the book. C is the right answer. What is a core service rendered by information utility? Core service of this one. And information utility is one of the pillar. I hope so you remember. Create and store the financial information, accept all electronic submission, get all the information received from the various person, and all of the above. The right answer is all of the above. Okay, so that is very simple one. So first of all, the summary we will do that there was need to have a effective law for recovery. Prior to this act, the recovery law were found inadequate, because we know that before this act, because this act was come into picture in 1993. 1993, right? And before this, the court handled these types of cases. Huge assessed of banks were involved in the recovery because huge pendency of the various court. Exactly. Suppose before 1993, when any case was, come in front of the court, so I think the court will not give the special weightage to the particular bank. Okay, so that's why they need to require. Okay, they need to require a particular, you know, we need a particular law so that the only debt recovery matter can easily be solved by the persons. Okay, so this affect the financial sector. The act was introduced in 1993. Initially, Delhi High Court decided the act as a constitutionally invalid. Exactly. The Delhi Bar Association, they just filed the case in the Delhi High Court that this DRT Act is totally unconstitutional, violation of Article 14. But when we just appealed to the Supreme Court decided no, 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 this act is totally valid, because this act is made for the particular things for solving the dispute. So that's why this act is totally a valid act. Okay, now applicability of the cooperative in this bank, the DRT Act will be not apply because there is a special provision. By the amendment in 2013, the applicability was extended to the multi-state cooperative bank. Okay, so it means that when it was decided by the Supreme Court that this act will be not apply, but now in 2013 this will apply to the multi-state cooperative banks. So preamble to the act state that the act is for expeditious adjudication and recovery debt. So the act is applicable for the depth of 20 lakh. This is very, very much important. Before it was only 10 lakh, but after that, after amendment, it was 20 lakh. So this is again important. Okay. In 2019, the name of the statute was changed to the Recovery of Debt and Bankruptcy Act. And before it was something like Recovery of Debt due to the Bank and Financial Institution Act. This was the act name. But after in 2019, the act name is this. So this is important from the examination point of view. Now let's do the question. DRT Act is applicable only if the debt recover is above 15, 10 or 20 lakh. What is the right amount? So for the right amount is that is a 20 lakh rupees. Okay. The debt recovered to DRT may be secured and unsecured. It means suppose if the borrower have taken money from the bank and financial institution, right? And something we have to security we have to give. So that is what? Secured or unsecured? So this is totally true. Okay, it may be secured, it may be unsecured. Overdrawn amount in an account is not debt recoverable under the DRT. That is true and false. Tell me. That is true and false. Overdrawn amount in an account is not in the debt recoverable stage. The third one is totally false. You have to remember. If a civil court has passed a decree, it has to be executed through that court only and cannot be come to the recovery tribunal. That is true. I don't think we have just done this. Suppose if civil court pass any decree and it have to be executed, and suppose this act come into picture. So this order can be executed by the tribunal also. So this is totally false. Is that okay? This is totally false. Next, that is a new segment. Okay. DRT was established by central government. The government also decide their jurisdiction. The tribunal consists one member, that is the presiding officer, that is the head of this one, appointed by central government. The central government can also notify to establish such DRT and its benches as it may be necessary and thus give the jurisdiction, power, authority, etc. Okay, and a new act is also come into picture, that is Insolvency and Bankruptcy Code 2016. What is the eligibility of presiding officer? Minimum he should be the district judge. Tenure is 65 or 5 year. Okay, whichever is earlier. And one and more recovery officer can be also appointed by the recovery officer by the central government. If you want to appeal, so filing appeal, the central government appoint appellant recovery tribunal, that is a debt appellant recovery tribunal. The head will be chairperson, and the qualification of chairperson must be minimum high court judge, presiding officer of at least 3 year, and legal officer of grade 1 post. So these are the qualification of this appellant. The appointment of this one is 5 year till he attend the age of, this is the qualification of what? This is the qualification of your this one chairperson. Okay, so that is important. Okay. Done, guys? So 5 year, 70 year, that is the tenure of this chairperson. The presiding officer and the chairperson can resign from the office, but they have to give 3 month notice to the central government. And central government can also, if it is proven misbehavior and incapacity, he can also remove the chairperson and the presiding officer. Okay, so this is the segment. Now next, DRT is established by, tell me. DRT is established by, that is the central government. Okay, DRT consists the benches of 3 person. That is totally false. Jurisdiction of appellate tribunal is with the respective of High Court. That is true. That is not true. That is a false, because tribunal have a separate criteria. Can the order of central government in the appointment of presiding officer of the tribunal can be challenged in any court? Can order of central government in the appointment of this can be challenged in any court? This is absolutely no. This is absolutely no. So for this one, B is the right answer. Okay, I think the all concept are very easy for you people. Okay, now let's do next. Okay, the bank has to file application for recovery of loan dues under the DRT, which is not paid by the borrower. Exactly, taking into consideration the jurisdiction and cause of action. Other bank and financial institution there that are also creditor to the particular borrower can join the application. Exactly. Suppose class, this is the borrower. The borrower had taken loan from the B1 bank, and borrower also taken the loan from B2 bank. Okay, this is the borrower. Not able to pay the loan to this and to this also. So B1 just filed the case to the DRT. B1 just filed the case. Just see the diagram. B1 filed the case to the DRT. So if the party is same, cause of action is same, so he can also file the case and the cases will be merged. So B1 bank case, B2 bank case will be merged. So this is your this line. Other bank also creditor to the particular borrower can join the application. So this is the right answer. Okay. For transfer from civil court to tribunal, no fresh fee is required to be paid. This section has given elaborate provision of the summon and hearing. That's it. Is that okay, class? Okay. The tribunal can pass interim order to prevent defendant from transferring his property. Interim order means that the mid order. The DRT is fully empowered to pass comprehensive order like civil code. So they have a same power just like civil code. This section also give the procedure for issuing the recovery certificate. So there are provision for appeal to the DRT. So we know that class DRT to DRAT. We have to file the case, okay, to the appellant tribunal. And for this one, we have to pay the 50% of amount. That is important. And the limitation apply for the DRT cases, which means bank has a normally file the recovery application within 3 years in the cause of action. It means DRT to DRAT, 30 days is there, right? And from this 3 year limitation period is there. Suppose if borrower or the bank want to file application, so there are 3 year of the limitation. That is important. Okay, this is important. Any doubt? Okay, now let's do the question. DRT jurisdiction for a bank is where head office of the bank is located. Tell me. Yes, class. DRT jurisdiction for the bank where the head office of the bank is located. That is absolutely false. If a bank has filed recovery application, other bank can join the application if the defendants are same. Defendant means the borrower is same. That is absolutely true. When a case gets transferred from civil court to tribunal, the fresh court fee is required to be paid? No. A counter claim filed before DRT has the same effect as the C class. In civil case, we know that the plaintiff is there and defendant is there, right? So plaintiff means the person who filed the case and defendant to whom we are filing the case. So defendant when counter claim, right? So the plaintiff is basically what? Plaint. The plaintiff will always file the plaint. So in that case, the plaint is the right answer. Plaint means when the plaintiff has to be filed the case. That is called plaint. That is important. Since DRT is not a civil court, it cannot pass interim orders such as attachment, injunction, receiver. That is true and false. Fifth, this is totally false because DRT is not civil court, but it can work just like a civil court. A person who has filed before appellant tribunal has to pay how much of amount? 50% of the amount. Okay. While filing appeal before appellant tribunal, if any amount is required to be deposited, A option is no amount is required to be deposited until appellant tribunal decide. Yes, court fee of the appeal amount is required to be paid. C. Yes, 50% of the amount determined by tribunal is required to be deposited at the time of filing of the appeal. And D. Yes, after admission of the appeal, 50% of the amount determined by tribunal is required to be deposited. So how much money that is required to be deposited? Tell me, class. That is C. C is the right answer here. Okay, C will be the right answer here. Done? Next. On receiving recovery certificate, the recovery officer has to proceed for the recovery by attachment and sale of movable and immovable property of defendant. Arrest and detention. It means these are the power of recovery officer. These are the power of recovery officer that he can attach and sell the property of borrower or arrest and detain the person or appointment of receiver, etc. Defendant is debarred from disputing the correctness of amount to the in the recovery certificate because defendant only presiding officer have a power. I think we know that for this one. So the presiding officer can correct the clerical and arithmetical error. This section has given wide enabling provision that call the money from the third party in whose hand defendant money is lying. Okay. It means we can suppose if the borrower money is within the hand of third party, so we can also call third party regarding this one. So that is important. Next. When amount belonging to defendant is in third party, the recovery officer issue notice calling for the money. The third party on failing to pay is deemed to be as a defendant. It means if third party is not giving money to the borrower, so that third party is also called as a defendant. If there is already a decree passed by civil court, DRT can issue recovery certificate. Exactly. No need to start the case from the beginning. Okay. The chairperson, presiding officer, staff of tribunals are deemed to be public servant. They are also protected from any action for their done in good faith. The act has overriding effect when there is a inconsistent with any other law. It means this act will supersede. This act will class supersede. First question. First question class, that is recovery officer appointed under DRT can attach, sell movable and immovable property against whom the order of the is passed by the party. That is true and false. Tell me, that is true and false. That is true and false. That is absolutely true. The defendant can raise a plea before recovery officer about correctness of amount ordered to be paid. Yes, the defendant can plea before recovery officer. That is absolutely false, because we know that only presiding officer have this one. If recovery certificate has clerical and ethical mistake, that can correct the same. Who will correct? I think we know that. That is presiding officer. Okay. For recovery of recovery officer can adopt the same method that apply in the income tax under the Income Tax Act. I think this line we have just read it. This line we have read it. For the fourth one, this is absolutely true. Okay, this is absolutely true. Recovery officer can ask the defendant to furnish by affidavit particulars of his assets. Fifth one. Recovery officer can ask defendant to furnish by affidavit particular of his assets. Assets means this belongs to me. That is absolutely true. A company is under winding up process. Okay. Whether High Court permission is required to a bank to proceed against it before the DRT. That is true and false. Sixth one. This is very important, and I think this thing we have just read it. That is no, because DRT Act is being special law, has an overriding effect over the other law. So for the sixth one, E will be the right answer here.
In the YT session also, we have just covered the module wise questions. We have covered the definition terms, and right now we are just covering the summary and its question. So this must, these are the things that we are covering in the session. So that's why these all terms are very, very much important. Now let's start with the today's act. Today's act is Insolvency and Bankruptcy Code 2016. What exactly this means? See class. We know that we have a court. We know that, guys, that we have a court in which justice will come, right? But the court is, Supreme Court is one, total High Court is 25, and district court and session courts are so many. So in this case, the substitute of court is ADR system. What is ADR system? Alternative dispute resolution. The ADR system is Lok Adalat, Ombudsman, Consumer Forum. Okay, Lok Adalat, Ombudsman, Consumer Forum. Then basically it's contain tribunal, right? Then arbitration, then conciliation, then mediation. So these are the ADR methods. So if we talk about the Insolvency and Bankruptcy Code, so this act basically talks about the insolvency. Insolvency means the person who is not capable to pay the debt. That is called insolvency. And what is bankruptcy? Bankruptcy means simply when the court will declare that this person is insolvent, this is called bankruptcy. So the bankruptcy is basically court declaration. This is court declaration. Is that okay? So this is your complete the ADR system. So in IBC code that is made in 2016, recognizing that reform in the bankruptcy and insolvency regime are critical for improving the business environment and
alleviating the distressed credit market, and the insolvency was passed by the government, which come into force in December 2016. Before class, this IBC code, before 2016, the insolvency matter was solved under the recovery of debt, okay, recovery of debt and insolvency Act 1993. So it means that your insolvency matter was solved by this act. In this act, basically we have to file the case to the DRT, right? But basically this act covered the recovery of debt matter. So that's why in 2016 when this act was made, so we just put our cases to the DRT and NCLT. So this is the crux of the first paragraph. Okay. The structure have 4 pillar. What is 4 pillar? 4 pillar means our government of India have a 3 pillar: legislature, executive and judiciary. What is the work of legislature? To make the law, to execute the law, to give justice. So these are the 3 pillar of government. So in bankruptcy code there are 4 pillar: insolvency professional, information utilities, adjudicatory authority, in which DRT and NCLT is there, and the Insolvency and Bankruptcy Board of India. So these are the 4, the pillars of IBC. Please read that pillars. This is very much important. Okay, class? Any doubt? Done? I think this is clear to all of you. Okay, so you have to remember this 4 pillar of government. Next. If the default is above 1 lakh, increase up to 1 crore by the government by notification with effect from the 2028, means if the default is above 1 crore, default is if the default is above 1 crore, okay, so the creditor may initiate insolvency resolution process, which include 2 stages. What is the first stage? The first stage is insolvency resolution process and the second is liquidation. These are the 2 stages. Suppose if Nikita ma'am is not able to pay the money, so in that case there will be 2 process in which the creditor can take money from the Nikita ma'am. The first process is insolvency resolution process. So there are step-by-step things in which we have to involve in this process. And the second is liquidation process. So first of all, we have to create this one and then after this one. Where corporate insolvency resolution process, what is the short form of this one? CIRP. Where the CIRP against a corporate debtor is initiated by financial creditor. It means this CIRP initiated by financial creditor, for example, a bank, it may file, because we know that basically the company, partnership firm, they just take loan from the bank. So the financial creditor, example bank, it may file application before adjudicating authority. So in that case, the bank will file an application to the adjudicating authority when default has occurred, along with the record of default, the name of interim resolution professional proposed. This is important. Okay. The bank also have to present the record of default and the name of interim resolution professional. So we know that what is resolution professional? That is the pillar of the this one IBC code. Okay. So interim means, suppose if there is a no resolution professional, so we can also appoint the interim resolution professional. Interim means for the temporary period. Okay. Now the application if admitted. Suppose if the bank have filed the application before adjudicating authority and that application if admitted, the adjudicating authority on being satisfied with result in the commencement of resolution process. So when application will admit, see, bank file application to the adjudicating body, right? If accept, then commencement of resolution process will start. Is that okay? So I have just complete the paragraph in a diagram. Under the code, the entire resolution process have to be completed. It means in this process, the entire have to be completed in 180 days, but may be extended for the valid reason for the maximum of 330 days. It means class 90 days extra will be given to this one. 90 days. 90 days extra will be given if 66% of committee of creditor will verify. This is very important. See, which may be extended for the valid reason for maximum 330 days, in which interim resolution process initially and resolution process later play a vital role along with the committee of creditor. So the committee of creditor, if you want the extra days, 66% voting is required. 66% voting is required. So under liquidation, the sale proceed would be distributed. So this is your with this one, and this is your liquidation process. So under liquidation, the sale proceed would be distributed as per the order of priority detail in the code using the waterfall mechanism. The central government also introduced the fast track. What is this? Fast track insolvency resolution. Okay, so the central government also introduced the fast track insolvency resolution process and pre-packaged resolution process, the latter meant for MSME. So this pre-package, okay, this is only for the MSME work, because we know that in MSME basically the micro, small, medium enterprises matter will become in this space. Okay, so suppose if there is a default, in this case we will organize this pre-packaged insolvency resolution process, and the corporate person may also enter the voluntary liquidation proceeding. So this is very, very much important. Please read all the points. Okay, please read all the points. Done, class? Okay. So this is important. Next question now. In respect of the real estate project, this is important. Real estate project. Real estate project of a corporate debtor
What is the minimum number of allottees who have jointly filed for initiation of corporate insolvency process? That is the CIRP. Tell me, class. In the real estate project of corporate debtor, what is the minimum number of allottees who have jointly filed for Tell me, class. This is very important. So this is B point is the right answer. 100 allottees or 10% of the total number of allottees, whichever is less. So you have to remember this one. Next. How much time is given by adjudicating authority to rectify the defect in the application of a financial creditor for initiation of CIRP against the corporate debtor who has defaulted? It means in how many days the adjudicating authority will give to just rectify this? Tell me. Okay, so this is within 7 days. Second, A is the right answer. Okay, A is the right answer. Next. Under IBC code 2016, which one of the following person is entitled to make an application to initiate the corporate insolvency resolution process? Tell me. A corporate debtor already undergoing the CIRP, a corporate debtor in respect of whom liquidation has been made, a financial creditor of a corporate debtor undergoing the pre-package insolvency, or none of the above. Which of the following is entitled to make an application to initiate the corporate CIRP? What is the right answer? So for this class, all are eligible. So that's why none of the above is the right answer. D is the right answer. What is the motive of enactment of this IBC code? What is the motive? First, to consolidate and amend the law relating to reorganization and insolvency resolution of corporate person, partnership firm and individual. Second, to maximize the value of asset of interested person, to increase ability of credit, and D, all of the above. Yes, what is the motive behind it? So in this class, all of the above is the right answer. Next. Applicability of code shall apply to company, LLP, partnership, or personal guarantor, all of the above. This act will be applied to what? This act will be applied to so in DRT, individual and partnership firm. In NCLT, this is company and LLP. So that's why all of the above is the right answer. So for this, D is the right answer. Next, who are considered corporate person under the provision of the code? Company and LLP, company and unlimited liability, financial service provider, company, LLP, trust. Corporate person, because whenever we start CAIRP, that is a corporate insolvency resolution process. So who considered as the corporate person? So in this case, A is the right answer. Who are person who may initiate the corporate insolvency resolution process? Corporate debtor, financial creditor, operational creditor, financial operation and corporate debtor, or corporate debtor, financial creditor. Whatever we have read in the paid class, every point is given here, every point. So for this one, the right answer will be, that is financial creditor, operational creditor, and this one. What is a core services rendered by information utility? And information utility is one of the what? It is one of the pillar of IBC. To create and store financial information, accept electronic submission of financial information, get all information received by the various person, and all of the above. So for this thing, the right answer will be, that is this one.
Oriented question. So now let's move forward the act. So today we are going to start the SURFACE Act. This SURFACE Act is important one. So what exactly the SURFACE Act? That is basically without, if I say you this thing in the one word, without intervention of court, how bank and financial institution can recover money, okay. So without intervention of court, how bank and financial institution can recover the money from the borrower, that is the main crux of this SURFACE Act. So as you can see that SURFACE Act was enacted with a aim to provide a structured platform to the banking sector for managing its NPA stock, that is a non-performing assets, and to allow the bank and financial institution to take the possession of security and sell them. So this is the main crux of this act, that it's allow, otherwise for everything we have to go to the court right now, but under this act the bank and financial institution can take the possession of securities and sell them. So this is a right which is given under this act, and this act is constitutionally valid according to the Maria Chemical case, because in Maria Chemical case we have learned that, okay, that this act will be valid one. This act has been largely perceived as a facilitating the assets recovery and the reconstruction. Prior to this act, it means this act is made in 2002, right? So prior to this act, the legal framework relating to the commercial transaction lagged behind rapidly changing the commercial practices and the financial sector reform, which led to the slow recovery of defaulted loan, and mounting level of NPA of the bank. We know that before this act, the NPA of the bank was increasing day by day, and there was a default in the recovery of loan. The comfort available for the lender of his money come back will give him a confidence for living. Okay, so the comfort, we are talking about the SURFACE Act. The comfort available for lender for his money to come back will give him a confidence of lending. So that's why, class, this act come into picture. This is very important. If I show you a one diagram that we have already done in the this one act. So this is your borrower, right? Borrower is there, and then suppose bank is there, and financial institution. So the bank will give suppose 20 lakh rupees as a loan, and the borrower have given the security. So under SURFACE, if borrower is not able to pay 20 lakh rupees, the bank will approach to the ARC company. That is Asset Reconstruction Company, always work under the RBI. Now this ARC company, what they will do, ARC company will take security and give money to the bank. After that, ARC company will search the qualified buyer. Qualified buyer will take security and give money. So this is the basic picture of your SURFACE Act that is important. Okay, basic picture. Now class, question and answer. Bank obtains security while lending so that in the case of need, money can be of securities. That is right and wrong. Tell me, class. Money obtains security. Bank obtains security while lending so that in the case of need, the money can be of security. Tell me, class, what will be the right answer? Bank obtains security while lending so that in the case of need, that is class, released by sale, resaled by. What is this? Released by, released by sale. This is the exact answer of this one. Let me correct my spelling. It's a REALIS, released by sale. So this is the right answer. Okay guys, this is the right answer for the first question. Okay, the SURFACE Act is applicable to the housing finance company whose name is notified by the central government. That is true and false. Tell me, class. That is true and false. SURFACE is applicable to the housing finance company whose name is notified by the central government. That second one is absolutely, that is true. Okay, this is the true answer. Okay, whether movable security in possession of bank can be sold by bank without intervention of the court. A option, now a court order is required to sell the security. Yes, bank can sell as provided in the Contract Act. Yes, as the SURFACE Act was made provision to that effect. Yeah, no, until the account is not declared NPA by the bank. What is the right answer? The mortgage property cannot. Third one. So this is the crux of your act, that yes, as the SURFACI Act has made provision to that effect. So say first one, C is the right answer. Okay, C will be the right answer for this question. Next. As per law existing today, the mortgage security cannot be sold without the court intervention. Is this correct? That the mortgage security cannot be sold without security, that is right one. This is about your movable. So it means SURFACI Act deal with both movable and immovable property. Is this correct? Fourth one. Tell me, class. So class, this is absolutely cannot be sold. No. The SURFACI Act has now made the enabling provision in which without intervention of the court we can sell the property. So for the fourth one, B is the right answer. Okay, next. Provision of SURFACI Act apply to which securities? Fifth one. Whether it is any movable, immovable property charged to the bank or financial institution. To mortgage security only, where security interests are created for repayment of financial assistance given by bank and financial institution, and to the property owned by defaulter borrower but whose are not charged to the bank. What is the right answer? Tell me, class. This act will apply to which security? So that is so simple. For the fifth one, the right answer is where the security interests are created for the repayment of financial assistance given by the bank and financial institution. So this is the right answer for this question. Fifth one, C is the right answer. Okay, next. In Madia case, what did Supreme Court declare as invalid? Yes, class. The A option is entire SURFACI Act. B is creation of security interest, formation of reconstruction company, or condition to pay 75% of the amount as a precondition while if you want to appeal in the DRT. What is the right answer? Yes, class. What is the right answer? The right answer will be for the sixth one, D is the right answer. Okay. Sixth one, D is the right answer. Okay. Now, next one. SURFACI Act in the book, there is a 6 to 7 chapter, so that's why this act is very important. In this unit, we have seen the various definitions given in the SURFACI Act, and guys, we have done the definition term in the definition session. The rationale behind enacting the act was to regulate securitization, reconstruction of financial assets, and the enforcement of security interest that is created in respect of the this one. So this is the first point, second point, third point. Okay. The SURFACI Act provide for the manner for enforcement of security interest by secured creditor without intervention of the court and the tribunal. Is that okay? As per SURFACI Act, any person aggrieved by the order passed by DRT, okay, under SURFACI Act, any person aggrieved by the order passed by DRT can file an appeal to the authority that is called appellant authority. Exactly. We know that if DRT is there, we can file the case to the DRAT. These tribunals are constituted by central government for various states as per provision of DRT, this act. This is very important. Okay, so under SURFACI Act also we have authority like DRT to approach. Okay, the act also provide setting the ARC. ARC means Asset Reconstruction Company, which acquire NPA from bank and financial institution by raising funds from the qualified buyer by issuance of security receipts. So whatever we have discussed in the diagram, that is the answer, representing the undivided interest in the financial assets. It enable ARC to take possession of secured asset of the borrower, including right to transfer and release the secured assets. The ARC buy the assets from the bank and financial institution, thereby cleaning the balance sheet of the bank and permitting them to focus on their normal banking business. So as we know that this is borrower, this is bank and financial institution, ARC company, this is qualified buyer. So this is the exact diagram of this one. So in the plain word, it is takeover of loans and advance from the bank and financial institution for the purpose of recovery. So this is the right answer. Okay, let's move toward the question. The SURFACI Act is applicable for the pledge security also. Pledge security class. Tell me. For the pledge security also, always remember the answer will be no, because for the act is not applicable to the pledge security because pledges deal with the Indian Contract Act. For enforcement of mortgage security, the court intervention is required, even the action under SURFACI Act. Second one. For enforcement of mortgage security, the court intervention is required when the action under SURFACI Act. This is the right answer. The answer is no. The court intervention is not required. Bank and financial institution can issue notice for enforcement of security under SURFACI Act only if these securities are not in possession of creditor, only when the account is classified as, that is very easy. Account is classified as what? So this is your, that is classified as the NPA. Okay, non-performing assets. If the borrower does not pay within dash days after notice by secured creditor, the creditor can dash the security. That is again important. If borrower does not pay within how many days after notice? So the notice period is different. It is not appeal. It is not class appeal. So for the fourth one, this is your 60 days you have to remember, and can sell the security. Take possession, you can say. That is, take possession of the security. Okay, take possession of the security. Next, after receipt of notice from the secured creditor for the repayment of dues by the borrower is legally prevented from transferring his property in the way. This is true and false. Fifth one. This is true and false class. Fifth one. After receipt of notice from secured creditor for the repayment of borrower, the borrower is legally prevented from transferring his property in any way. So this is absolutely true. Yes. On request of secured creditor, the district magistrate and chief judicial magistrate can take possession of security from handing it toward the creditor. That is true and false. Sixth one. So these things you have to remember. On the request of secured creditor, the district magistrate and the chief judicial magistrate can take possession of security. The answer is true. When the management of company is taken over by a secured creditor, the director of such company are entitled to compensation for the loss of office. Why the director will pay? Why the director will pay? So this is not the exact answer. So that is false. Why only director will pay? Okay. When any bank or financial institutions obtain the charge against property with which authority will be transaction, have to register with the SURFACI Act 2002. 8th. So to whom we have to register? To whom we have to register? When any bank, financial institution obtain a charge against property with which authority will be transaction to be registered with the central registry. 8th, A is the right answer. When can provision of SURFACI Act be invoked for proceeding against charged property? When the bank feel that it is necessary for recovery at time, when RBI direct, when there is a default in repayment by the borrower, or when there is a default in repayment and the bank declare account as the NPA. Ninth one. That is again very simple. For the ninth one, the right answer will be when there is a default in the repayment and the bank declare the account as a NPA. So ninth, D is the right answer. Whether existing or future receivable are property. Yes, yeah, no. 10th. Property may be in existence or in future. So the correct answer is yes. From which of the following function is of securitization company? Tell me, class. 11th. Acquisition of loan transaction from lender, help the lender in recovery by sale of charged property, take legal action against defaulter, and acquisition of financial assets from the originator. And who is originator? That is bank and financial institution. So for this one, the right answer will be D. Okay guys, so for today's, I think that's all for today's class. And SURFACI Act have a 7 to 8 chapter. So right now we have done the 2 chapter, okay? So rest of all we will do it tomorrow. Okay, so that is a very, I think this one chapter, a very large chapter. Okay, so now let's meet you tomorrow with the same
I
timing.
hope so you people
And
like the session. So today we have just covered the MSME and your insolvency and bankruptcy code. So if you want to join the session, this is your AIM batch. Okay, you can use the coupon code Y391 for the maximum discount up to 81%, right? So this is your CAIIB AIM batch. Okay, this is your CAIIB AIM batch. You can see here, you can purchase the batch. In the batch, you will get the live classes, recorded session, PDF, mock paper, etc. So if you want to enroll, you have to use the coupon code Y391. And this is your elective paper video course, because in the single paid batch, the video course are not available for elective paper. If you want to join the live classes of elective paper, so it will be available in the CAIIB ka Mahapack, because in CAIIB ka Mahapack you will get everything for 1 year. Okay, if I just show you the Mahapack, this is your CAIIB ka Mahapack.
So if you want to enroll it, you have to use the coupon code Y391, and on the occasion of Holi, the discount is going on, right? So if you want to purchase it, the process is very simple. Google Chrome, click, okay. Then after, you have to write down Adda 24/7, click on all courses, done. And this is GIB CIB June 2024. First of all, this is your AIM batch. This is CIB ka Mahapack. So if you want to purchase it, click on buy now, put the coupon code Y391. If you click on apply, you can see 80% discount is there. That is for the 1 year of validity. Is that okay? So you can see here, include all the new and updated syllabus, include mini marathon, mega marathon, so everything, whatever you want. And elective paper live classes will be also available in this CIB ka Mahapack. So enroll it now to just clear your concept and crack this exam in the